Hi, everyone. Welcome back to Texas Business Court Insider. I'm Rachel Roosth, and I'm here with my colleague, Kate Ergenbright. Kate, can you tell our viewers what we're discussing today?
Today, we're covering a new opinion from the 15th Court of Appeals, which is the Texas appellate court that all business court appeals go to. The case we're going to be talking about today is captioned In Re Frank Jackson. It was decided on July 14th of this year. And it's a mandamus proceeding out of the business court. The central issue in this case is attorney immunity in a corporate in-house setting. Chief Justice Brister wrote the majority opinion in this case, and Justice Ferris dissented. Now, Rachel, why don't you give us some background on attorney immunity before we dive into the details of this specific case?
Attorney immunity is a long-standing Texas doctrine. It protects attorneys from civil liability to non-clients. It applies when the conduct at issue involves the unique professional skill and authority of an attorney performed to fulfill duties to a client in an adversarial context. It has been recognized in Texas for over a century, and it applies in both litigation and transactional settings.
This immunity is not unlimited, right? It doesn't apply to attorneys at all times, does it?
That's right. It does not protect conduct that is entirely foreign to the duties of an attorney. So a key question is, what kind of conduct was involved? That's going to be an important issue in our discussion. But first, let's give the viewers some factual background here. Kate, can you walk us through the relevant facts?
Happy to. The plaintiff in this case is Norman Thomas Barros, the former CEO of Reynolds and Reynolds. Now, under his employment agreement, if Reynolds and Reynolds terminated Barros with cause, he would only receive accrued benefits. But if it terminated him without cause, Reynolds and Reynolds would owe him the compensation he would have been due for the remainder of his term as CEO. So you can see where this is going. Reynolds and Reynolds terminated Barros in May of 2025. Their position is that termination was for cause, and Barros claims the termination was without cause, and that Reynolds and Reynolds owes him $350 million.
Kate, you mentioned earlier that the mandamus proceeding was styled In Re Frank Jackson. So how is Frank Jackson relevant here?
Frank Jackson is an attorney who Barros also sued. Barros claimed that Jackson tortiously interfered with Barros's employment agreement with Reynolds and Reynolds by advising the defendants to fire Barros so that Jackson himself could claim the CEO role.
Got it. So what happened after Barros was terminated?
Barros sued Reynolds and Reynolds for breach of contract. He also sued Jackson and the majority owner of UCS, which is the parent company of Reynolds and Reynolds, for tortious interference. The defendants then removed the case to business court, and Jackson sought to dismiss the tortious interference claim under Rule 91A based on attorney immunity.
How did Barros respond to that?
Barros amended his petition, like many litigants facing a 91A motion. In his first two petitions, he alleged that Jackson was the general counsel of UCS, the parent company of Reynolds and Reynolds. But after Jackson moved to dismiss based on attorney immunity, Barros removed that language from his petition and instead called Jackson a business advisor that, quote, happened to have a law license. Now, Rachel, why don't you tell us how the business court ruled on the motion to dismiss and what happened from there?
Sure. The business court denied the motion to dismiss, and then Barros filed a petition for writ of mandamus to the 15th Court of Appeals. The majority of the 15th Court of Appeals then ruled in favor of Jackson based on his attorney immunity claim. According to the majority, the allegations in the petition established that the other defendants were Jackson's clients or client representatives. The majority also noted that the termination letter was attached to the petition and thereby incorporated into it. And that letter described Jackson as the general counsel of Reynolds and Reynolds, or the company as it was written in the letter.
Now, Rachel, how did the majority address the allegation that Jackson was acting as a business advisor that just happened to have a law license?
The majority focused on the conduct actually alleged as tortious, which here was advising on a CEO termination when $350 million of potential liability was on the line. The majority said that despite Barros calling it business advice, that advice is precisely the kind of work corporate attorneys and general counsel are expected to perform. So the court found that attorney immunity barred the claim against Jackson, and it conditionally granted the writ of mandamus against the business court to dismiss the lawsuit. Kate, tell us about the dissent.
Justice Ferris wrote the dissent, and she focused on the Rule 91A motion to dismiss standard. Now, under 91A, courts must accept all factual allegations as true and liberally construe pleadings in the plaintiff's favor. Dismissal under 91A is appropriate only when recovery is legally impossible on the face of the pleadings.
So I guess Justice Ferris did not think the dismissal standard was met here.
She did not. Now, she walked through specific allegations in her dissent, like an allegation that Jackson conducted meetings with Barras's subordinates and an investment team, an allegation that Jackson inserted himself into business operations far removed from legal issues, and an allegation that described Jackson's role as being in the capacity of a director of the majority shareholder of Reynolds and Reynolds rather than acting as an attorney. Now, taking all of that as true, Justice Ferris concluded those allegations were more characteristic of a general business advisor than someone acting in a capacity as an attorney. Now, she also pointed out that Barras only needed to allege that some of the interfering conduct fell outside of the protective category for the claim to survive at the pleading stage. Now, Rachel, why don't you tell us how the majority responded to the dissent?
The majority had two main points. First, the majority said none of these activities had anything to do with terminating Barras. Pleading that an attorney performs non-legal work does not establish that the specific conduct alleged as tortious falls outside attorney immunity, at least according to the majority.
And what was the second point, Rachel?
The majority addressed Justice Ferris's concern that this holding would shield attorneys acting in their own self-interest. The majority said that attorney immunity focuses on the function being performed, not the attorney's motivations. The court said, or the majority said, that Texas law does not require attorneys to be altruistic. It also said other mechanisms already exist to address attorney misconduct, like sanctions, contempt, and bar discipline, without exposing lawyers to civil liability from adversaries. Kate, what do you think are the main takeaways here?
I see two main takeaways. First, the majority's opinion is pretty protective of attorney immunity, even in the face of creative pleadings. So there may be a lot of in-house counsel breathing a sigh of relief here. Now, the second is that litigants should be careful what they attach to their pleadings and remember that those items are incorporated into the pleading itself for the 91A dismissal stage. Now, here, attaching the termination letter that referred to Jackson as the general counsel of Reynolds and Reynolds to the petition actually worked against the plaintiff here. Is there anything you'd like to add, Rachel?
Yes, keep an eye on this case. In her dissent, Justice Ferris stated that if petitioned, she would invite the Texas Supreme Court to review the case. She said that a high-level attorney in a business often has a blended role, and the line between business and legal functions is blurry. So she believes the attorney immunity issue is ripe for guidance. So I think this is a case to follow, and I will be interested to see whether the Supreme Court addresses this issue.
Me too, Rachel. And to our viewers, thank you for watching Texas Business Court Insider. Please hit like and subscribe so you won't miss our new videos.
And check out our Texas Business Court Insider Hub via the link below for all of our other videos and thought leadership. We'll see you next time.